national education policy, and even uh, just day before yesterday, uh, the bill which has been placed before the Lok Sabha, so that will change the entire regulatory framework in India. So bill which is like already in consideration, and most probably by this Friday, this bill will become act. After President signs, then this bill will be applicable under Article 111 of the Constitution. This bill will become act finally in there. So bill actually what is that is subsume UGC, AICT and NCT. Adhistan Bill 2025. So this bill will change the regulatory framework of the legal education. And in fact, in the debate in the parliament, some of the members have raised issue about that education is the subject of the, also focused on a very important aspect which we missed. What we have been, and even our Prime Minister has spoken in some of the political speech, we have to move from the Machiavellian mindset to the Indian knowledge system. So like he also said, what we are like more Western style of teaching we are doing, we are learned everything in Western, it has to be more Indianized education is there. So focus even in the national education policy on the indigenous legal education and also on the Indian knowledge systems. The first point which you have in the mind, whether the national education policy 2020 in its view covers the legal education or not. The first, whether legal education part of the, even in this Anustan Viksit Bharat Rajasthan Bill 2025 has made it clear that it doesn't apply to legal education and medical education. Similarly, national education policy, it says it doesn't cover the legal education, medical education, and also agricultural education. So, in one hand, we have been told, we have been informed that national education policy is not much relevant to the national law school. You have to go according to the Bar Council of India. So, can we take a liberty or totally reject the national policy and focus on the direction of Ministry of Law and Justice and also on the Bar Council of India? For example, just a day before or 2 days before, the Ministry of Law and Justice, what we discussed in the morning, and that is very important, they are working for many days to include in the legal education legislative drafting, they say legislative drafting and also plain language. That too, also Law Ministry recently conducted a meeting of the Honorable Vice-Chancellor of National Law School, and they requested all the National Law School, and gradually it will go to the other law school also, to focus on the legislative drafting. That is also, and also focus on the plain language, simple language. So language has become a good concern. The Supreme Court also there is a case pending, several case is pending in the Supreme Court, where they emphasize why should we mug up the Latin words, Greek words, and so language. So clients can understand what is the position of the case. So it's not full of the legal jargon or legal terms. It's become so parties have no idea what is happening. It's only the court and judges. So simple language. So recently, the Law Ministry has asked all the law schools, and then subsequently Bar Council of India also instructed all the law colleges to focus on two important aspects, on the legislative drafting one, and second is the plain language. So already the process is going on. So we receive directions from the other sources. We are not getting something from the national education policy. But if you think holistically, and in deep manner, you can come to the conclusion a national education policy covers everyone. Bar Council is an body which sets certain kind of guidelines and says these are the fundamental papers you have to teach for 3 years students and 5 years students. So in the schedule 2 of the Bar Council regulations, they mention 20 papers. The 20 papers is fundamental papers which you have to teach if you want like. And then also says the 4 clinical papers which is also mentioned 21, 22, 23, 24 where they say these 4 papers are also compulsory, the clinical paper which exposes the students to the real courtroom exposure. So these are the compulsory papers, and rest of the papers are college can decide like it's because now we offer BA LLB, BCom LLB, BB LLB. So it's an integrated courses. So 13, 14 papers in the social sciences paper, if management, 14 papers in the management, if commerce, 14 papers in the management, we have to teach along with the fundamental papers. The rest of the papers can be coined and designed by the teachers as an elective papers. So like law schools focuses on the elective papers, optional papers. So you give the liberty to the teacher to think about and introduce new papers, and depends upon the student's preference. If the student like the teacher, they opt for the paper. Then, so that flexibility is there. So we can, like what we discussed, what we learned in the morning session, we can implement that in our course curriculum in the area which is open for us. So what area is open for us? Elective papers are open for the optional papers are open where we can start a new paper and where we can teach them. Coming back to the national education policy, a law education is incomplete without the university. So this is university. It's not a law school. This could have been National Law School Tripura. Government said the National Law School Tripura. But one act has established National Law University. Now the university, which institution can offer degree? Degree can be offered by the university. A college without recognition of the university cannot offer a degree. So degree conferring power has been given only to the university. And universities are 4 types of university. So this is National Law University created by state government, by state assembly. So basically in a nature, National Law School is not national. It's a state creation. It's not the parliament has created. Central University is a central because it's created by parliament. National Law School, so many people say, and we also say, it's a state university. The way state university is created, the same way by act of assembly, it has been created National Law School. So which institution, which government has created? Tripura government has created, not the government of India has created National Law. Name is national. So what we aim at to have a national character of the law school. National character. They say, okay, so state university like IP University, Indraprasth University in Delhi, Delhi Tech, Triple IP in Delhi, the medical college in Delhi. So Delhi University has many colleges, engineering, law, or state by supported by the Delhi government. So what they do? They say, you have to admit 85% students, only those who passed from the Delhi schools. Not from this. 85% seats are reserved only for the students of Delhi. So that's not national character. Here some way it's a balance. He will admit as far as possible state quota, but we want to admit the students nationally also. So this is some way character-wise is a national. And that is how. Nature-wise, it is a state university. But character, it is a national because it allows some scope for the students more in a cosmopolitan way. So National Law University, all National Law University, including National Law University, Bangalore, also created by the Karnataka University Act. So this is all our state university. Only the nature we can have more students from the other parts of the country. So first thing, university is important. If you remove the national law, Tripura, only university can confer the degree. So first, university becomes very important. Now university has to be governed by national education policy. And we are not coming to bar council right now. So now university, when the word university, so the national education policy says that all university has to follow the pattern what has been said, what the method of teaching, what kind of courses, what is the So some way I say if like you go much deeper, outrightly saying a national education policy is not applicable, may not be appropriate. So national education policy applies even to the law schools, in the legal education. Though they have said, what they have said, we are not on the regulating board. We are not going to regulate and affiliate every year or 2 years like Medical Council of India for the medical education. So regulating part we leave it to the Bar Council of India. So Bar Council of India, what it does, you apply. You say we are meeting the conditions which has been laid by the Bar Council of India, and accordingly you give us affiliation. You renew our affiliation. अगर first time में आया तो affiliation for the fresh affiliation or नहीं तो extension of approval of affiliation. Extend the approval of affiliation because we meet the condition which has been set by the Bar Council of India, and that is there. So then we see that role of the both are interrelated. University and Bar Council of Education. They have not gone much into detail. And some of the challenges which many students are, we find where we have to work, where Bar Council of India has to think about, and the university system is there. So university system, it says, national education policy, it talks about more or less 3 types of universities. One is the, they say, the research-based university. Then another is the teaching universities, teaching and research, both will be there. And the third one talks about autonomous colleges. The third one, the autonomous colleges. All colleges affiliated to the respective university should aspire to become autonomous colleges. Means autonomous colleges. So once they become autonomous, so you also become more or less as a law school. You can set your question, you can draft your course curriculum. So aim of national education policy, which is applicable to the affiliated law colleges. I give you an example. There are 2 law colleges. One is the Vivekananda Institute of Professional Studies in Delhi. They applied for the autonomous colleges. So they are affiliated with the IP University. They applied for the autonomous colleges. Autonomous colleges status has been granted. Now university has to give a no objection. So problem actually with the university giving no objection. Because university gets some money every year. So they are losing their fund, affiliating colleges, they get some money. So that is the problem. Then another is the Chota Nagpur, like the Ranchi, Chota Nagpur Law School. So law school can be, but who has given the status, autonomous status? Where they got support to get this autonomous status? They got because of the national education policy. They could have said, no, it's only the Bar Council of India will recognize whether you are autonomous college. So recognition of autonomous colleges has been done by the University and University Grants Commission of India. So university, your status has changed. So I say the national, and this is possible because national education policy aims to make all colleges autonomous colleges by 2030 and 2040. That is one of the aim of the autonomous colleges. Though it's moving very slowly, gradually it's moving, it's not picking up. Actually, so many years have gone. So I see if there is a scope of looking national education policy and the Bar Council. Outrightly say, Bar Council because legal education. So what legal education the autonomy legal education enjoys, that it comes to the Bar Council of India only in affiliation and extension of affiliation. Like new college, fresh affiliation, and old college like your college, it's an extension of approval of affiliation which Bar Council of India did. So Bar Council of India has a role to play once a college is recognized or affiliated by the university. No college can approach Bar Council of India directly and say, you affiliate, then we will go for the university recognition. Recognition of the Bar Council is precondition. that university has recognized your college. So the first stage, when even if you think about establishing a law college, you have to obtain affiliation from the university. Once the university has affiliated, then you can apply for the Bar Council of India. Of course, both are equally important. But first, I place on top, I place university. University has to be governed by the National Education Policy 2020, and that has been clearly stated. There is only one place that is mentioned under the page 51 of National Education Policy, where we see about the legal education. The reference under the National Education Policy, only one place we find some kind of reference about the legal education, and that is under paragraph 20.4. 20.4 paragraph, which talks about, and that also helps us to understand the picture of the legal education. Only one paragraph. So entire document, National Education Policy, which contains around 50 or 52 pages, out of 53 pages, only one paragraph you find the reference of the legal education, that is mentioned in page 51, paragraph 20.4. So simply if you jump and look into 20.4, is there. So now that 20.4 says what kind of legal education we should have. So it says the legal education should, we'll read in detail later on, it should be competitive. It takes the promote the constitutional values. So in essence of 24.4, it talks about the competitive legal education. It talks about the evidence-based of legal teaching. It talks about the comparative, how other jurisdiction is there, working on the particularly comparative globally, and also embracing the best practices. So you have got an idea when you make the syllabus like now. So in the morning we are struggling to make it the syllabus. If we look into the 20.4, which gives us also further idea what our syllabus should be. So syllabus should not be confined to the national jurisdiction. Syllabus should be competitive with the global perspective. Syllabus should also take note of the comparative perspective of the different jurisdictions in there. Syllabus should also, your course curriculum should also adopt best practices prevailing in the other countries. And of course your syllabus, whatever subject you teach, it must based on the constitutional ethos and constitutional values. That is the important. You say, I'm not teaching constitution, but constitution is linked with everything. Constitution is an idea which gives how to treat dignity. It talks about the liberty. It talks about number of things. So essence of the constitution must be somewhere reflected in your writing. And that is, I mean, article. And it also talks about the rule of law. It talks about the human rights. Entire in one paragraph, it gives you complete holistic idea about the legal education in 20.4. I said it should be rule of law, human rights, democracy, instrumentalities, separation of power. So everything is there in few lines, which is a great help for all the teachers to look into when it comes to this. So outrightly rejecting the national education policy doesn't apply. That Bar Council of India can say, the national education policy will not restrict our way of recognizing colleges. Will continue, they can continue. But university can always ask a college why you are not calling this school. You modify your syllabus. The syllabus is approved by the university senate body. In a big university, it's that the state senate or the other relevant bodies, academic body, approve the syllabus which applies to a large number of colleges, 60, 70 colleges in the state concerned or affiliated to that particular university there. Let's go back and try to understand. So points which I have already highlighted. Now I'll just read it out, 20.4. So what we learned from 20.4, it talks about the constitutional values, it talks about the justice, social, economic and political, it talks about the national reconstruction, it talks about rule of law, it talks about the human rights. These are the things are mentioned under the 20.4. A close reading of the it says 20.4, legal education needs to be competitive globally. तो आपको अभी जो भी लीगल एजुकेशन करना है तो सिलेबस चाहे आज इतने सब्जेक्ट हम पढ़ते हैं इसमें कहीं ना कहीं हम वी आर नो लॉन्गर एज ए क्लोज कंट्री वी हैव लाइक नो more or less integrated in the global system. So our legal system, our other system also need to be reformed according to the global fixed practices. And reform has to be at the domestic level. But while reforming, you take note of the other jurisdictions, how they are dealing with that particular aspect. If you ask any students, if you want to see how artificial intelligence can be regulated, where you will go? Artificial intelligence. Then you say that there is a European Union is working. So some jurisdictions work much faster compared to the other jurisdictions. So when we discuss about the artificial intelligence, you have to refer. You have to talk about the EU regulations. When we talk about the environmental law, domestically you can start with the MC method or you can go back to the Bardichan is there. But I tell you that all the teachers of environmental law, what we have missing or what we are not taking note of, when we teach environment law, we focus more on the Bardichan. We start with the 1972 Stockholm Declaration and we immediately come back to the Water Act, Air Act and Environment Protection Act of 1986, that main umbrella legislation we go and we teach. We talk about the MC Mehta cases, series of MC Mehta cases and other cases we discuss. But in the process, to understand the environment law, we must teach a student the global development of the environment. United Nations Environmental UN Framework Convention on Environment, that is the Paris Declaration, Conference of Parties, series of development globally are taking place. So our teaching must complete or must be included the global development in the environmental law and domestic law. So environmental law cannot be understood solely focusing on the domestic perspective. If you teach perfectly fine, but the students have half understanding. So adding or including international perspective is very important in the environment law. Same applies in the copyright, same applies in the patent, same applies in the human rights law. You name. So interdependence of the global practice and domestic practice become norms in today's time. Norms. You have to follow, you have to incorporate. So how much you can do, as I said, while making the syllabus, you have to also balance. You can't cover everything what I am saying. But what you can, you find they are indispensable, that cannot be dispensed, that has to be added. So some basic idea needs to be incorporated in the syllabus, while drafting in the syllabus. Let's go to the 20.4. It says legal education needs to be competitive globally. So it starts with the legal education needs to be competitive globally, comma, adopting best practices and embracing new technologies. So technology and new technology for wider access to and timely delivery of justice. At the same time, it must be informed and illuminated with constitutional values of justice, social, economic and political, and directed towards national reconstruction through instrumentation of democracy, rule of law and human rights. So you see, and it also so just one paragraph, it gives you complete idea. So national education policy somewhere given us idea of how we have to progress, how we have to. There are conflicts where students and then bar council and university system comes into the conflict. Now they say in the university system, national education, lifelong learning process. तो आप जिंदगी भर पढ़ सकते हैं. So if you first year you get a certificate. Suppose you enroll in the undergraduate program, you spend 1 year. For any reasons if you leave, you get a certificate. If you complete 2 years, you get a diploma. So each year is recognized. पहले तो नहीं होता था incomplete. Then you always say कि I'm 12th pass. I have joined. अब फर्स्ट करके इस साल पे किसी जिम्मेदारी के कारण you get a certificate and you can start second. You can come back and join. You don't need to join the second. You admit in the second. That's a lifelong learning. Third, then you get a degree and 4 years you get a research degree. So अगर 4 साल की आप कर लिए, 4 साल आप पूरी समय के हिसाब से कर सकते हो, किसी जगह से भी कर सकते हो, क्रेडिट ट्रांसफर में तो बहुत सारी फ्लेक्सिबिलिटी हैज बीन इंट्रोड्यूस्ड. अब लॉ एजुकेशन में पहले था शुरू में prior to 2008. So what it happened? It allows lateral exit. The undergraduate in the university system let the concept of lateral exit. आप जाओ और आप आओ. आप जब भी पढ़ना चाहो आप आ सकते हो, जा सकते हो. तो lateral exit का concept उसमें exist कर रहा है. लेकिन अभी में लीगल एजुकेशन में अगर फिर 9 सेमेस्टर भी लड़का पास कर गया है और 10 सेमेस्टर किसी कारण से छोड़ दिया, he may come back and complete in 2 years time. There is no problem. 10 semester if he has, but in 2 years time he has to complete. It's a university rule. Like some years within 2 years you come back, you can readmit and you complete your 2 years of 3 years. Lateral exit has not been introduced in the legal education. तो हम सोचते हैं कि अगर 12 के बाद 3 इयर्स के बाद एक बीए की डिग्री मिलती है, तो सिमिलरली एक 3 साल लड़का अगर लॉ स्कूल में रहता है 5 साल बालक, क्योंकि 12 साल के जो 16-17 साल के 18 साल के बहुत बच्चे होते हैं वो लॉ स्कूल में आते हैं, and then they realize legal education is not his or her forte. That's a wrong decision he has taken. He wants to come out. He wants to come out from that. And then if he come out, he wastes all 3 years as a zero. So it's very difficult. So the lateral exit, which was the practice, lateral exit has been closed after 2008. Prior to 2008, lateral exit was legal education was there, but because of the law school and others, they said, you know, 20% students prefer to come out, given a chance. Even in the national law school, I say 10 to 15% students will opt out after doing the 3 years of illegal education. They will not pursue. So that freedom is restricted in the legal education. So there is a demand for the lateral exit. So Bar Council has to take. Now, National Education Policy permits. Bar Council Regulation 2008 says no lateral exit. So if when you read the lateral exit, National Education Policy, you find a positive answer. Regulation 2008, Bar Council, it says no lateral exit. So that is the problem. So bringing the synergy between National Education Policy and regarding the lateral exit, it depends Bar Council also to agree upon lateral exit should be reintroduced, and that is possible through the amendment of the existing regulation. So these are some challenges are there when it comes to the National Education Policy and Bar Council of India. But role of the university remains relevant. No college can offer a degree without the Bar Council, without the affiliation of the university. Even the college fulfills all the conditions of the Bar Council and is not recognized by the university cannot give a degree. And the students, even Bar Council gives a degree, that degree is not valid, not recognized. So university becomes very important in the legal education, medical education, or any other education university. Thus, the application of national education policy remains relevant, useful for all stakeholders, whether it's a legal education, whether it's a medical education. So some important points which we need to take, which we need to adopt in the day. You are not restricted, you are not prohibited to follow the 20.4. What we have discussed, so 20.4 is not putting any kind of bringing anything There is conflict between the university and Bar Council of India. It gives you a direction कि what you can, how can you improve your curriculum. First is कि competitive. आप कितना पढ़ाते रहोगे अपने हिसाब से. अगर आपके cases आप पढ़ा रहे हो Constitution पे Directive Principle of State Policy, you have to go in the South African Constitution. If you have Constitution पढ़ा रहे हो तो Transformative Constitutionalism आपको पढ़ाना है. तो South Africa के Constitution से 1994 में ये बातें आई तो उसको चित्र करनी. तो you have to bring the development in the various jurisdictions. And that is the reason that say it should be competitive. It should not be a narrow and a closed door that is there. You want to ask something?
Yes, मेरा नाम रमेश दास है. इसके लिए मेरा क्वेरी था, मुझे इसके बारे में जानकारी नहीं है. All I wanted to know is that कि नेशनल क्रेडिट फ्रेमवर्क है, उस क्रेडिट फ्रेमवर्क में कुछ क्रेडिट ट्रांसफर
हाँ, क्रेडिट तो ट्रांसफर हो गई. जो आप क्रेडिट बैंक में जमा किए हो, क्रेडिट ट्रांसफर हो गई है.
That provision is there for the.
हाँ, it's a credit like an academic credit bank, so you bank में आप डिपॉजिट होता है.
The another question is with respect to the clause 20.4. जो studies international across the globe होता है और जो इंडिया में होता है, when the study curriculum are somewhat different based on the geography, culture and country about over time. When certain cases are fought in ICJ, so is it affecting those cases, like if there is a case which is fought between two different countries for the similar nature, is the study or curriculum which is out of practices impacts those cases when it is fought? It is just a query from non-law side.
Compared to that, अभी आपके बात से दो चीज का पता चला. एक है कि डिसीजंस ऑफ द इंटरनेशनल बॉडीज और रीजनल बॉडीज और बोथ. सो लाइक यू टॉक्ड अबाउट द डिसीजन ऑफ इंटरनेशनल कोर्ट ऑफ जस्टिस. सो इट सेड इंटरनेशनल कोर्ट ऑफ जस्टिस इज नॉट क्रिएटेड बाय स्टेट ए, स्टेट बी, स्टेट्स. स्टेट का क्रिएशन नहीं है, भले ही हेग में फंक्शन कर रहा है, but it has not created by Netherlands. So it's an institutional based arrangement. ये आता कहाँ से है? See, this is International Court of Justice is one of the principal organs of the United Nations. तो उनके judicial wing भी United Nations की, जैसे वहाँ पर है. अब International Court of Justice के decisions हैं, वो precedent में नहीं आते, उसको precedent की यूज़ नहीं होता है. But अभी recently जैसे advisory opinion मैंने states obligation related to environment 25 जुलाई 2025 को आई है, बहुत important judgment है. That makes each state bound by the decision. The states will be held responsible in the implementation of the environment. So ये open advisory opinion है, open to all the member states of the United Nations. तो जो बातें आप बता रही है इंटरनेशनल इंस्टीट्यूशन, सुबह मैंने यूरोपियन यूनियन बताया, मैंने ये नहीं बताया इंग्लैंड, मैंने ये नहीं बताया फ्रांस, मैंने ये नहीं बताया जर्मनी, मैंने बताया यूरोपियन यूनियन, मैंने बताया यूनाइटेड नेशन. अब जो इसमें कह रहे हैं कि कंपैरेटिव, यहाँ पर हमें एक डिस्टिंक्शन लेना होगा. जब हम कंपैरेटिव बात करते हैं तो कंपैरेटिव द डोमेस्टिक लॉ ऑफ द अदर कंट्री, तो वो कंपैरिजन है डोमेस्टिक लॉ ऑफ द अदर कंट्री. तो इंडिया में कॉन्स्टिट्यूशन पहले तो साउथ अफ्रीका में किस तरीके से कॉन्स्टिट्यूशनल प्रोविजंस आर एप्लीकेबल, एक नेपाल में क्या हुआ है, श्रीलंका में क्या, तो कंपैरेटिव पर्सपेक्टिव में देखा. तो कंपैरेटिव पर्सपेक्टिव में हम बात करते हैं तो वी हैव टू थिंक अबाउट द डोमेस्टिक लॉ ऑफ द डिफरेंट कंट्री. सो देयर इज ए थिन लाइन डिफरेंस, वो कभी-कभी ओवरलैपिंग होता है. बोलते हैं सर आई एम डूइंग कंपैरेटिव स्टडी. सो व्हेन यू डू द कंपैरेटिव स्टडी, सो मींस यू स्टडी द local system or domestic system of the different countries, USA, UK, Germany or something. You say that you are doing the comparative study and also you are studying the international institution, international law applicable to this particular matter. Then institution पे role important आते हैं. और whenever the ICT के advisory opinion applies to all 193 countries. So there is no like those who are a member of the United Nations, it binds all these things. So comparative जो हमारे 20.4 में है, और course, it can include also. There is no restriction. So comparative can be also institution, international institution, and domestic also it can be. So as I said, when you teach the environment law, you should not only remain confined to the national laws. You must incorporate some of the developments which are taking place globally under the international and regional institution. So ये चीजों को आपको you have to put in there in your syllabus. और किसी के?
In view of the judgment of the Supreme Court regarding the attendance policy of the law school, so like how your university, what is the discussion going on in your university, and how you are implementing the decision?
Yes.
Or
he. So मुझे लगता है कि आपको सभी को पता होगा, बहुत सारे व्यूज हैं इससे रिलेटेड भी ये सुशांत रोहिला जजमेंट तकरीबन 26-27 पेज या ज़्यादा है शायद, 110 पेजेस सुशांत रोहिला जजमेंट जो एक नई लीगल एजुकेशन के लिए पहले इसको if I don't read the judgment, I can outrightly say this judgment is not applicable to the National Law University Tripura. ठीक है, क्योंकि decisions of the High Court binds the its own jurisdiction, and not necessary rights. The decision of the Supreme Court, according to Article 41, 141, it applicable to all the subordinate courts to the country. सारे जितने कोर्स हैं 141. तो outrightly कह दे कि दिल्ली वाले नहीं. So यहाँ पर ही जब when you read the judgment, you have to go to the origin. So origin says when the boy committed suicide, next day in 3-4 days, I think in the 16th August 2016, he committed suicide, lack of attendance and harassment by the teacher. So he said he committed suicide, and then his friend has written a letter to the Raghav Sharma, wrote a letter to the Chief Justice of India, saying, the arbitrary practice, harassment, lot of things he had mentioned. The Supreme Court committee took this matter, discussed in 2017, and simultaneously a criminal case was also filed by the family members in the trial court. The criminal cases, primarily criminal case भी चल रहा था ये. The Supreme Court, in 2017, the judgment says this judgment is delivered or taken. This matter was discussed by the court, decided because of the order of the Supreme Court of India. Otherwise, जो लास्ट इम्पोर्टेंट पॉइंट्स हैं उसके हिसाब से खाली दिल्ली के कॉलेज को लगना चाहिए, लेकिन when the Supreme Court has ordered, Supreme Court said कि you examine, and then court has looked into the all this. So court word बाद में suo motu they have taken, but order of the Supreme Court. So decision some way the main जो ratio is it appears to be applicable to the all law schools. When it comes to there is no problem. Some of the practices which we were which we were following, and there your role is important. You as a teacher, you have to play an important role. होता क्या है कि 10%, 15% attendance when you miss, so BCI also allows, university also allows, go for remedial classes, go for special classes. So their teacher says कि अरे अभी हम इतना नहीं है, फिर से लेना पड़ेगा. So teachers become reluctant in taking the extra class. Some teachers say कि I am not going to take any class, whatever happens, because I have taken all 60 classes. I am not going to this boy. He never came in the class. Now he is coming and says कि take 20 classes in there. So that become an issue there. And this is the cases, not one paper. In all papers, some way you will find 2-3 students got stuck. So this is the challenge internally there. So Bar Council also says you take the remedial classes. You take remedial classes, give the attendance, and then allow them to appear in the examination and that particular thing. But now in this say, the court says, you do something, even if not classes, online classes, you can give a hard assignment to write, or anything you do, and then last it says, okay, so this can be applied only in the gap of 10%, 15%. But last ratio is said, no one shall be stopped अब 0% भी है तो उसको भी देना है, ये क्या करना है? तो these are the questions and no one shall be stopped. Even if attendance is hugely short, you allow him to appear, allow her to appear, then only you deduct 5% marks. 5% marks. So it says that like the gap which is there, like so everyone has to be permitted. That is there. Some of the colleges have implemented. We have not said we are implementing, but we have mentioned we are giving you permission. We have allowed. I said don't break your head on the judgment. I said we have allowed subject to the direction of the Bar Council of India or Bar Council. So we have permitted. Some colleges, we have still adhering to. So, but ultimately it's creating a problem for the institution, and institutions are handling in the way they want. But in Delhi, particularly National Law University Delhi, they allowed everyone to give. Delhi University, they allowed give to the institution based in Delhi. They have followed 100%. Rest of the institutions are partially implemented. And when they say there are a lot of gap is there, they say you come back. If it goes to the court, and then we have to see that. But Sushant Rohina's judgment is taking note of why students should come to class. Why you are asking? These are the basic questions. When the technology, so teacher is not for transforming knowledge. Now you are simply a facilitator. You facilitate, you give the knowledge, yahan padho, wahan padho. They have everything. Why should? So the judgment has posed a different question. Why you are insisting when technology, knowledge, information is spread? If a student outside the class, they also say if students are participating in the extracurricular activity, that should be also taken, not limited. कि मूड कोर्ट में 3 नंबर, 2 नंबर, मूड कोर्ट में डिबेट में, you add everything. So extracurricular activity should not be given, should be also regarded, not limited 3%, 2%. So some way, number of things have changed, and I also believe why I ask for students to come to the class. But if you do your justice, if you go to the class, people will come. 1 or 2 students are there, but 90% students, of course, when they come into the 4th year or 5th year, their approach towards the legal education change and transform because they have become more concerned about the placement, job. So they have a little bit laxity interest in the 5th year, the last year of the 5th year 5-year education. Anything else? Anyone? सुबह के क्लास से, शाम के क्लास से, आपने लॉ सर को तो जल्दी छोड़ दिया। मुझे लग रहा था कि लॉ सर 3:15 बजे आए, जब घड़ी मैंने देखा तो वो 2:15 ही बजे थे। बोले कि जल्दी आए। All right, so we continue the another part of the, which is also 20.4, talks about the first part I have covered. The second part also it talks about, which we discussed in the morning. So 20.4 is a lengthy, to one paragraph we discussed rule of law instrumentality. And it also talks about the curriculum. This is the second part of the 20.4. It talks about the curricula for legal studies must reflect social cultural context. Social cultural context along with in an evidence-based manner. In an evidence-based manner. So legal teaching में कहते हैं evidence-based legal. और evidence means scientific. You prove जो आप कह रहे हो case law से लाके evidence-based manner, focusing more on the case law evidence-based manner. The history of legal principles of justice, the practice of jurisprudence and other related content appropriately and adequately incorporated. State institution offering law education must consider offer bilingual, মানে বাংলাও পড়াতে পারবে, হিন্দিও পড়াতে পারবে, ভোজপুরি পড়াতে পারবে, যা ইচ্ছা করে পড়াতে পারবে। Bilingual education for future lawyers, judges in English in the language of the state which the institution is located. So it's also promoting local language which is there in the legal education. So it's not, so there are a lot of reforms is there because the Bar Council says English is the only mode of international law school. So the local language is also important, which is part of 20.4 is there. And of course, local language is very important. If in West Bengal or Tripura, if you ultimately when you go in the court, you interact with your client, poor client in Bangla. If you go say, how are you? You tell me what happened. The key bolche bujhte parlam na kichi answer kore kore katha boleche amake. So that will be like so you have to interact, make yourself accessible. Then judge bhi jo baat karte hain, wo bhi Bangla mein zyadatar karte hain. So language is important. You can't sideline the language the way we have been doing. And many good students are not able to clear the state judicial services because they some way they are out of touch of their mother tongue. They studied in the English school, so when it comes to writing in the examination, speaking in the classroom or in the interview, so while High Court focuses on the local language, this says whether you are familiar because they know कि court में तो वहाँ पर lawyer will also speak, client will also, or जो accused है, victim है, everybody will speak local language. So somewhere balancing is important. The local language should also be given a preference along with the English. There is no harm because if you read in English, if you think in English, you are connected globally. Or if you only focus on the local language, you are connected locally. So that is the advantage and disadvantage. So learn both, use both, and then move on with that. Nachiketa, I think English बहुत ज़्यादा हो गई. Education policy only in higher education. That is आपको if national education policy is divided into 4 parts. So first part is school education, not required. The second part is higher education. So higher education जो है page 33 to 49. So only we have to read page 33 to 49 or 51 basically 51. No, page 33 to 49 higher education and other key areas. जो मैं 51 का उसमें legal education किया आपकी page number 51. So only 16-17 papers if you read, you get the entire what I have said and said. I will not ask you to read 53 pages. Reading only 33 to 55 is sufficient to understand all about the national education policy. I end by thanking all of you and wishing you a wonderful 5 years learning. Of course, learning or don't unlearn, keep on learning and enjoy your day here. Thank you very much. Thank you.